Mr. Attorney General, you are acting today like the president's personal attorney. And that's the whole problem. You've got you have a whole banner of his face hanging over the Department of Justice, and you and everybody else walks under it. And you are acting like you're his current personal attorney.
You do not belong in this job, Mr. Acting Attorney General. You should always and recuse yourself from these issues because you are the president's lawyer. You are not the lawyer for the United States. Yes, you are.
Hi again, everyone. It's 5 o'clock in the East. Trying to make smugness great again, I guess, is his plan. That's Donald Trump's personal lawyer. I'm sorry, Donald Trump's current acting attorney general and appointee to be the country's attorney general under intense scrutiny this week as he will appear before Senate Judiciary Committee members on Wednesday for a confirmation hearing. Todd Blanche can't afford to lose even one Republican on this, or else his nomination to be the official and no longer the acting attorney general will be dead. Today, a development that further calls into question whether Todd Blanche's true allegiance is to Donald Trump, who he represented as his personal criminal defense attorney, or to the country, a question that has been looming over Todd Blanche since he joined the Trump administration. Judge Kathleen Williams ruled that Donald Trump's lawsuit against the IRS, which Todd Blanche settled in May, was brought for, quote, improper purposes. She writes, quote, the nature of the suit itself and the conduct of the parties and counsel from its filing makes plain that this was an attempt to use the court to provide some legitimacy to an agreement to confer immunity to people and entities affiliated with the president and to earmark billions of dollars from American taxpayers to redress grievances not defined in the law. On the context of that filing, the New York Times writes this, quote, the decision by the judge, Judge Williams, who sits in federal district court in Miami, did not explicitly kill the deal that Trump had worked out with his own government to receive what amounted to amnesty from IRS investigations. But the scathing ruling exposed the negotiations between Trump's personal lawyers and senior officials at the Justice Department for what she says they were backroom dealings that did not arise from a legitimate legal process. The judge, Judge Williams, ordered Rule 11 sanctions against Trump's lawyers in the case. Todd Blanche, the acting attorney general and the nominee to be the country's attorney general, is among them. Rule 11 sanctions are basically fouls or penalties imposed on lawyers when they file frivolous lawsuits and abuse the judicial process. What this means is that 2 days before Todd Blanche heads up to Capitol Hill to try to bamboozle Republicans and be confirmed as the nation's top law enforcement official, he himself is staring down rather unprecedented potential disciplinary action for being a bad faith actor in court. That is where we begin the hour with the founder of the Public Integrity Project and former special counsel in the Justice Department, Brendan Ballou. Also joining us, publisher of The Bulwark, Sarah Longwell is back, plus political analyst, former Senator Claire McCaskill joins us. Brendan, your thoughts?
I think it's a real sign of how the judiciary is thinking about the Department of Justice right now. You know, DOJ still has the same name. It still has the same building. But in terms of what it stands for, how it works, and how it's perceived by courts, it's just a radically different institution than it was 24 months ago. I think it's frankly very encouraging that Judge Williams was as aggressive as she was, both in directing Todd Blanche for potential bar sanctions, but also for the amici, the amicus brief judges who submitted a really important filing on that, and all credit to Norm Eisen and the legal team that was behind that, ordered that they can recoup their attorney's fees here, which I think really lays the foundation for judges ordering monetary fines from the Department of Justice when they act like this. So at some level, it's a very sad indictment of where the Department of Justice is. At another level, I think it's a hopeful sign of how courts are starting to reckon with the reality of where we are now and hopefully present something of a roadmap for what they can do in the future.
I mean, Brendan, one of the sanctions for breaking Rule 11, as you said, could be monetary. The other could be pro bono work. What if Todd Blanche is ordered to work for you?
I think that's extraordinarily unlikely. I also think we, try to be pretty selective in the lawyers that we work with and their legal skill. But I think, the issue here is, they have referred him for, potential sanction by bar committees. Candidly, bar committees are really not very active in these sorts of highly charged political disputes, so I don't think your viewers should really expect much in the way of action. Not that this isn't any shade on the bar committees, but I think they are really, really protective of their jurisdictions and don't want to be seen as political actors here. Even if nothing particular results in terms of punishments for Blanche or punishments for the other lawyers here, it really does send a message about the department's credibility at the moment. And that's something that really has a ripple effect, not just in this court, but in all courts in the United States. And I think is going to make it much harder for Blanche and the Department of Justice to do its job generally.
Maine voters already seem aware of that importance, with Republican Senator Susan Collins' reelection campaign in trouble, specifically because of how she votes in Senate confirmations for federal judges, including Supreme Court justices. The judge's ruling in this case came in a court case titled President Donald J. Trump versus Internal Revenue Service. The question before the judge was simply, was it a real case? Or was it a fake lawsuit brought by Donald Trump against himself, since Donald Trump is in control of the Internal Revenue Service and the United States Treasury, the two defendants Donald Trump was suing? As you heard from legal commentators on this program, including Andrew Weissman, a lawsuit has to actually involve what a court calls adverse litigants, meaning the two parties actually have to be opposed to each other. Andrew has pointed that out repeatedly about this lawsuit. The judge determined today that this lawsuit did not actually involve two sides, but was really Donald Trump just suing himself. And in her 56 pages of dismantling the Trump fake lawsuit piece by piece, Judge Williams patiently waited until page 43, just exquisite work as a dramatist, page 43, to use the smoking gun given to her by the stupidest litigant in history to ever sue himself.
I'm sort of suing myself. I don't know. How do you settle the lawsuit? I'll say, give me X dollars, right?
Right. And so, on page 43, the judge writes, certainly a court should not be a forum for a party that cynically views a lawsuit as a vehicle to achieve a predetermined outcome. I'm suing myself. Quoting Donald Trump there from that appearance. In the rare cases where judges are forced to figure out whether the parties are really adverse to each other in a lawsuit, they pretty much never have the plaintiff in the lawsuits saying publicly on television, I'm suing myself. That is Donald Trump's unique contribution to the history of this kind of case. And yet another demonstration at the same time of the reason why careful litigants never say anything publicly about their cases. And the stupider the litigant is, the more dangerous it is to say anything publicly about their cases. The judge found that the lawyers on both sides of the case abused judicial process in order to set up a structure in which Donald Trump could be granted a generous settlement by his own Justice Department in a case that was fake to begin with. It was a way for the Trump government to give Donald Trump $10 billion. Donald Trump sued the Internal Revenue Service and the Treasury for $10 billion because a contractor for the IRS released portions of Donald Trump's tax returns to the news media several years ago. Even though Donald Trump filed the lawsuit after the statute of limitations had passed, the Justice Department that he controls did not object in court to a lawsuit being filed after the statute of limitations had passed, something the Justice Department has done in all similar lawsuits. The judge called the lawsuit performative litigation. Judge Williams carefully grounded her findings in Supreme Court cases written by Donald Trump's allies on the Supreme Court, including recent Supreme Court cases, affirming the Republican legal position that every person working in the executive branch is under the direct control of the President of the United States and therefore acting for the President of the United States. The judge quoted a Supreme Court opinion issued just last month saying Article 2 requires that the president control all executive power, especially the authority wielded by agency heads who are the most important of the president's subordinates and who must be the president's alter egos in their agencies. The judge said Donald Trump was suing his alter ego, Treasury Secretary Scott Bessent, and that the case was settled by his other alter ego in the case, Acting Attorney General Todd Blanche, who previously served as Donald Trump's criminal defense lawyer, which left him, Blanche, in a decision-making position reeking of conflict of interest in this case. The judge's opinion implicitly turned on the assumption of abject and absolute cowardice on the part of Scott Bessent and Todd Blanche. The judge wrote, Secretary Bessent in particular is subject to President Trump's actual and direct control in both of his representative roles. First, as Secretary of the Treasury Department, Bessent is a member of the President Trump's cabinet. In this role,
you already know this is about to get ugly because Donald Trump has never handled the word no like a normal person. He does not like hearing it from judges, from political opponents, from voters, or from anyone who refuses to treat him like some untouchable monarch. In Trump's mind, disagreement is betrayal, accountability is persecution, and a court ruling against him is automatically proof that the system is corrupt. But this time, the judges told him no, and that matters because they did not invent some new legal theory just to block him. Their reasoning follows principles the Supreme Court has already established. Donald Trump does not get to escape the ordinary responsibilities of American citizenship simply because he once served as president, is serving again, and will always carry the title of former president afterward. We continue calling former presidents president as a sign of respect, but that title is not a lifetime immunity card. It does not erase tax obligations. It does not cancel civil judgments. It does not transform personal financial disputes into official presidential business. And it certainly does not place one man above laws that apply to everybody else. That is essentially what Trump keeps demanding. His position is that because he held the presidency, anything involving his taxes, his money, his records, or his legal exposure should somehow be separated from the rules governing ordinary Americans. He wants executive privilege stretched so far that it becomes personal privilege. He wants the protections of the office without the responsibilities of citizenship. In other words, he wants one legal system for Donald Trump and another for the rest of the country. But the court said no. Even this conservative Supreme Court, which has handed Trump major victories on executive authority and right-wing policy, has still drawn a line between presidential power and personal immunity. It has often given him wide latitude when he is carrying out genuine duties of the presidency. But when the issue is personal, money he owes, civil liability, tax obligations, or conduct unrelated to governing, the courts have been far less willing to indulge the fantasy that he is untouchable. And lower court judges pay very close attention to those signals. When the Supreme Court establishes a principle, judges across the country look at it and ask how it applies to the next case. They may not interpret every detail identically, but they are expected to follow the basic direction. That is exactly what happened here. The message could not be clearer. Donald Trump is a president, not a king. He can attack judges, insult them, threaten political consequences, and pretend every defeat is part of a conspiracy. He has done it before, and he will almost certainly do it again. But none of that changes the law. He can rage at the system all he wants. Judges are still going to rule, and when the facts and precedent are against him, they are still going to tell him no.